again here, this amendment here. I covered this in the longer video, but I'm just rereading it again now. This, right? Although this is for normal law, it homages the process of bringing petition to Congress or to the federal government. That would be, see, in all criminal prosecutions, the accused. Well, when you bring a grievance, you're accusing. When you bring a grievance by lawful due process to the government, you are accusing them, particularly if it's a grievance of doing something wrong. And Parliament Petitions Committee keeps saying, "Oh, you can't do petitions about wrongdoing." Well, what's a grievance? You can't have a grievance, and if you've got a grievance, what is it against? Something that is not right. Shall enjoy the right to a speedy and public trial. Well, the thing is with a petition, you're gathering evidence from the public, evidence of public concern, and it's kind of been brought to the public, and it usually is not speedy. It usually takes quite a while to collect all the signatures or evidence by an impartial jury of the state. Well, that's ironic because in a petition, usually they're not impartial. You're usually getting everyone who supports the cause to sign. But, ironically, then it says, of the state and district wherein the crime shall have been committed, which district shall have been previously ascertained by law, and to be informed. Well, previously ascertained, well, you're setting out your, like when Extinction Rebellion are saying that, people are climate criminals or whatever, they're supposedly ascertaining all facts against these climate businesses and companies who are causing damage to the climate and planet. They're meant to be ascertaining this. They're meant to be ascertaining it, and setting out their accusations that these companies are breaking the law anyway, and to be informed of the nature and cause of the accusations, to be confronted with the witnesses against him. Well, this is the thing. Usually when you're doing a petition, you're collecting everyone who's in favour of one side, right? This is the thing, like in the Tumultuous Act, if it was over 20 signatures, then it had to be checked by a grand jury, which is meant to kind of be a mixture of people in it. But then, you see, people are open or welcome to oppose it, They can oppose it. They've got a right to oppose it. To have compulsory process for obtaining witnesses in his favour and to have the assistance of counsel for his defence. Well, you're meant to enjoy. Where's the? We do enjoy for sure in the claim of right. We definitely enjoy the right not to be imprisoned. You definitely enjoy the right not to be imprisoned for petitioning, but that covers all of it, the whole thing, all of your activities and engagements, which are claimed for that purpose, which would include, I suppose, even if you were breaking the peace. Now, the thing with the senators when they claim breaking the peace, if you're in the senators get to vote on their own selves, like within the Senate, that they get to vote on each other's conduct and so forth, kind of like in the Magna Carta with barons and lords going to be fined by their equals. There's definitely, I know for certain that when you're bringing cases to the government, it definitely you've got an existing case, and all if anything comes in question about your behaviour or conduct, it's meant to be brought under the level of which you're bringing the petition. It's not meant to be tried at this common law level. But there is a kind of sort of argument that some people will put forward that the ministers are sending you to court, or the Parliament is sending you to court, but they're not supposed to send you to the common law court because you've already got people supporting for or against anyway. And I know you're not meant to be imprisoned. Why would having the representation of the people act that you can't be imprisoned? They can only be fined.